Well, welcome everybody. We're really glad that everybody could join us for today's presentation about the USDA's new Heirs Property Relending Program. I'm Nicole Cook. I'm the legal specialist with the Agriculture Law Education Initiative at the University of Maryland Eastern Shore Extension. I'll be moderating today's panel presentation. And I'm very excited to introduce you to our presenters. Our first presenter this morning is going to be Leah Petersen, and Leah is a farm loan specialist with the USDA's Farm Service Agency in Annapolis. And our next presenter is attorney Jesse Hammock, and Jesse is a partner at Parker Counts. Jesse represents businesses and individuals on the Eastern Shore, and he has extensive experience resolving disputes and counseling clients in estates and trust matters, real estate matters, and guardianship and family law disputes. Just a couple housekeeping items. We're going to let our presenters speak, and then we'll have time for questions from the audience. I'm going to recommend that people please type your questions into the Q&A box, and I'll obviously be monitoring that box, and we'll try to get through all of your questions before the end of the program. If there are questions that we aren't able to get to, or that would require some maybe extra time, our presenters and myself will work on getting a response back to you. This program is being recorded, and we will send a copy of the recording along with a copy of the slides to the email address that you use to register for this event. So without further ado, Leah is going to kick us off. Leah, go right ahead.
All right. Thank you, Nicole, for the introduction. I will pull up the presentation here. Okay, so Heirs Property Relending Program. Just to give you a little bit of background, the idea of the Property Relending Program is to provide loan funds for eligible intermediaries that can relend that money to individuals and entities that are have an undivided ownership interest and having issues resolving that and getting the succession resolved on the farm. So heirs property is land that's inherited without a will or legal documentation of ownership, and heirs property is land that is jointly owned by descendants of deceased persons. So the purpose, again, is to assist them with the undivided ownership interest and succession planning. So I feel like, okay, we're just a little bit ahead here. So a couple of things that the agency does require with all programs is environmental compliance. And there is a process that we have to address those things. Typically within our application process, we request things from the lenders regarding the property and I guess what we're referring to as ultimate recipients, the folks that will get the money to resolve the issues. And so there's questions that are answered. It has to do with highly erodible and wetland certification laws that are in place. And so those are part of the application process. And we would be in communication with the lenders to answer any questions and ensure that those things are addressed upfront. And so intermediaries would make the loans to eligible ultimate recipients. So like those would be our lenders that are out there working with the ultimate recipients to put the loan funds in place for them so they can address the succession issues that they're having. Ultimate recipients are the individuals. And so assisting heirs with undivided ownership interest pay fees associated with the succession plan, consolidate fractional interests. So those are some of the uses and authorized loan purposes for the Heirs Property Relending Program loan proceeds. So when we talk about eligibility requirements of an intermediary, we're talking about cooperatives, credit unions, nonprofit organizations. Intermediaries must meet eligibility requirements. So certified as a community development financial institution, to operate as a lender, the citizenship. So the applicant of the members of the intermediary must be US citizens or qualified aliens. there must be some experience, capability of making and servicing agricultural and commercial loans similar in nature to the Heirs Property Relending Program, have legal authority necessary to carry out the proposed loan purposes, obtain and provide security and repay the proposed loan, and demonstrate the ability and willingness to repay the loan based on the intermediary's financial condition, managerial capabilities, and other resources that they have available. So the eligibility requirements for an ultimate recipient, they have to be an individual or legal entity that can incur the debt. So for some of the things that we run into occasionally with entities specifically is where they're operating. So if they're operating in the state of Maryland, but there may be a Delaware entity, do they have the authority to operate in the state of Maryland? So some of those questions come up, and those would be things that we'd be addressing in the case of like an entity like that. Members of an entity must be a family member or an heir-in-law related by blood or marriage to the previous real estate owner. And they have to agree to complete a succession plan. So loan limits for intermediary lenders, it's a $5 million limit for each lender. The interest rate is 1% with a 30-year maximum term. And currently, ultimate recipients it's a $600,000 limit per ultimate recipient, and this interest rate would be set by the lender. So things that the loans cannot be used for is land development, acquisition or repair of buildings, payment of operating costs, finder fees, or similar costs. Any purpose that would contribute to excessive erosion of highly erodible land or conversion of wetlands. Resolve heirs property issues on property that won't be used or traditionally has not been used to farm or for agricultural purposes. So the loan amount can't exceed the current market value of the land. So whatever an appraisal would determine would be the maximum within, of course, the limit. And intermediaries who receive the funding are not permitted to charge the ultimate recipient for mediation services provided through grants received under the agency's state mediation program. So this program is being administered out of our national office in Washington, D.C. So entities that are interested in becoming an intermediary lender would submit an application between August 30th and October 29th of this year. The property will be implemented again in our national office. The lenders would complete an application and with supporting information and send it to the address on the screen. Additional application periods will be announced in the Federal Register. So this is currently the announced application period. And then this particular program is completely separate from the American Rescue Act plan of 21. So I think Nicole said that we are going to wait for questions. I'll go back to you, Nicole.
Yeah, thank you, Leah. And I don't see any questions at this time posted, but we definitely will come back and look for questions. So thank you so much. And so Jesse, we're ready for you.
Great. I assume everybody can hear me. I muted and unmuted myself. So
yep, you're good to go.
that's the extent of my technical prowess. So Leah, you started off and you set such a high bar, and I'm never going to be able to get over that, because all these people are going to do is watch me gesticulate and talk for 15 minutes. My name is Jesse Hammock. I'm a partner with the Easton-based law firm of Parker Counts. I've been practicing for approximately 20 years. We have offices in Easton and Cambridge, and we encounter heirs property issues frequently that my firm does a substantial amount of estate administration, estate planning and estate administration. Our estate planning clients don't have this issue because, as the name notes, they are planning. Oftentimes, heirs property issues arise when there was no planning done. And therein lies the problem that clients that, and we have dealt with, in particular, one family that had the heirs property issue from 80s, where there's multi-generations and literally hundreds of properties and fractional shares. But I'll get into that later. As more of a picture, what I thought I would talk about is one of the practical steps that folks can take when they find themselves in a circumstance where they have heirs property, which, as Leah pointed out, where you essentially have real estate that is passed by operation of law without estates being opened and deeds being recorded that convey the property interest from one level of the family down to the next level, and sometimes even down to the next level. So first step in, from my standpoint as a lawyer, in resolving an heirs property issue is to find out everybody that owns the property. And the way that we do that is by employing a title company to do a title search. So the title search, as most people know, a title company will go through the land records and the which includes both the civil court records and orphans court record, which would indicate whether or not estates have been opened and whether the property has been properly, or when the last time it was that the property was properly distributed, because that's going to be your starting point. So if mom passed away and the only child is living on the property, and this is the simplest example I can give, the title company would find that mom inherited the property from her mother and father, and that was the last time the property had properly passed title. We would then have to fix the fact that only son doesn't currently have title to the property. We would have to go back and reopen mom's estate and have that property distributed by deed from mom's estate to the son's estate, which, I'm sorry, to the son, hopefully not the son's estate, the son, at which point that very simple heir property issue has been resolved. Now, that's as simple an example as I can give. But the first step in the process, always finding out who owns property and when the last time it was up the chain of title that it was properly conveyed, because that's going to give you your starting point in untangling the heirs property mess you have. The complexity of the mess is the next step, the next bite of the apple that you take. And there, the complexity is determined by a couple of factors. Number one is how many generations you have to go back. In my earlier example, you only had to go up one generation, and there was only one heir to whom you had to distribute the property. Oftentimes, what we have found is you actually have to go back multiple generations. And so to maybe grandmother or great-grandmother, which then makes the genealogical tree far more complex and brings in far more people that you would have to get involved in order to clear title. For example, and use my earlier hypothetical and build on it a little bit, if you go back one generation to mom, but instead of there being one son, there are three sons, the three of them have, depending on how the property was deeded, we're assuming that there is no joint owner and no successor owner, and there usually never are, identified in the will. You can't pass property, deed outside of a will like that, other than joint owners. Is to, if you have three sons or daughters and a son, you then have three owners of the property, and in some circumstances, one of those three has also passed away. And then the question becomes whether or not that sibling's estate has been opened, whether there is a will. If there is a will, to whom did the brother or sister leave their property? including what's called a residuary clause. So property that you don't know you own, will be caught in what we call a residuary clause, which basically says any other property I have that I don't know about goes to my nephew or whomever you leave it to. So the more siblings there are and the more generations you go back, it exponentially complicates the amount of work you have to do. Once you find out the last proper conveyance, the step is to open estate for the person that should have received the property, administer that estate, convey the property out. You repeat that process over and over until you get to the final generation of owners, which is the current generation. And hopefully you can find all of those heirs and therefore transfer the property in as clean a manner as possible. Oftentimes you can't, and so this is where some of the problems come up in resolving the heir property issue. When you know that Aunt Beatrice, who has a 1/3 interest in the property, had 3 kids, but she moved to Missouri, and one of the kids may have died, and we're not sure if they had kids. In order to figure out who owns the property currently, we, the attorney and the client, have to resolve those genealogical issues, because we have to give notice to those potential property owners. We have to convey title to them, and in order to do that, we have to find them. So that becomes a problem when there are distant relatives who have a fractional interest that you can't locate. That's when you get deep into the weeds, and there are all kinds of procedures courts and lawyers employ to give fair notice. It could be if you turn to the back of the classified ads, you'll see a bunch of legal notices in there. The reason why those notices are there is because lawyers like me can't find people sometimes. We have, and we're obligated to by the rules, constitutional due process, and orders of court, give notice to unknown heirs or any potential unknown creditor before we pass title. Another complexity or another issue that causes complexity is whether or not these distant heirs had wills. If they didn't have wills, if they had, in order to open an estate for somebody, we have to have a personal representative. And a will typically name the personal representative. That's the person. The reason we need them is that is the person that has the authority to open the estate. We have to find those people in order to get those estates opened so that we can convey the property. Another complexity that we run into when we're administering the estates is, and oftentimes these are estates that may have been not administered years ago. There are no other assets except for this fractional share interest in the heir property. And as you might expect, most lawyers that I know don't work for free. There are taxes. The federal government always, and the state government always comes a knocking their share of, and it may be a nominal share, but it's a cost nonetheless of their tax interest in the property. So as you're opening these estates, what we are counseling clients, among the other issues that we are counseling them on, is the cost associated with going through this process. The cost of not only title search, which depending on the complexity of or how many generations it goes back, how many siblings at each level there were, you could be talking anywhere between $300 and $3,000 for a title search. As I mentioned at the beginning, and Nicole, you're going to have to remind me when I get close to my 15 minutes. If you have multiple pieces of property, you have to do that title search for each one of those pieces of property, because oftentimes, depending on who died first, you have some siblings that had wills that divided up their interest in certain proportions. You have others that don't have wills, and it's divided equally between however many heirs they have. If you have that issue, as we did with one family in Dorchester County, literally 130 different pieces of property, everybody can do the math. It gets exponentially more expensive. You end up having to sell property, pay to convey some of the property, and then it becomes a balancing act, which you have to involve the orphans court and property appraisers, which adds additional cost. in determining which property should be sold in order to pass the others. The final issue that I wanted to address is what happens when you have unknown heirs. There is I alluded to it earlier. If you find, for example, as I said, Ellie had 3 kids. She moved to Missouri. 1 of them may be alive, 2 may be dead. They may have had kids. You're absolutely going to have to employ counsel, potentially in multiple states, in that circumstance, to give notice to unknown heirs. And there is a publication process depending on the court, and this also varies judge to judge within courthouses sometimes. The level of detail, there's publication notice, there's posting on the courthouse door, there are a number of mechanisms, sending to last known addresses. There's a whole body of law that says if an address can be discovered for a person, you may have an obligation to actually send notice to that last known address. There's a due diligence process that the attorney and the estate personal representative has to go through. It has to be certified to a court. It can get very cumbersome, very complex, depending on all of these factors. So it's how many generations do you go back? How many siblings are there at each level of each generation? Were there wills at each level of each generation, or was some of the property passed by laws of intestacy? When you don't have a will, there's a statutory scheme that says how your property is distributed. Do we know who all of the potential heirs in the heirs property issue are? And do we know where they are? Then at the end of that, you have potentially is 35 people with a 1/35th interest, a piece of property. One person is farming and paying all of the carrying costs for, and the other 34 didn't even know they owned. And the real difficulty and complexity comes when those 35 or 5 or 3 people don't agree and don't get along. So that's really kind of the general subject matter that I wanted to cover. Nicole, I should have looked at the clock when I started, and I failed to.
You're absolutely fine. And if you're done, we'll wrap up with that. But you do have a couple more minutes if there's anything else that you wanted to mention.
Well, yeah, I guess a couple of things is and the professionals that you're going to need involved, it's good to know ahead of time. And this is not to, I mean, this is what we do. So it's not necessarily an advertisement. I have one client current that tried to go this alone, and it's costing more to undo some of the problems it would have. So there's a penny wise, pound foolish aspect to it. Lawyers are not expensive, and I understand that. And there are programs, especially on the Eastern Shore. I will tell you, I know that there is an entity called Midshore Pro Bono. I know that my wife runs it. It helps those that are disadvantaged that find themselves in an heirs property dispute. I'll put in a plug for Midshore. They conduct programs up and down, well, as the title connotes, Midshore, where they help folks that don't have the means to hire a lawyer and hire accountants to walk them through this process, explain to them the resources. They don't actually do it for you, but they tell you where the resources are that you can go to resolve these issues. So there are resources out there, whether if you have the means to hire a lawyer. I highly encourage that a couple of hours of a lawyer's time, while it may cost several hundred or $1,000 or more, is money well spent on the front end. It will inevitably, I promise, it will save you money on the back end. But if you don't have that kind of upfront disposable income, there are pro bono legal organizations throughout the state. If they can't help you do this, you can get you to the people that can.
Thank you. And that is also the point of the lending program as well, right?
Exactly.
So let's talk about that a little bit more. Thank you so much. Thank you, Leah. Thank you, Jesse. We do have some questions coming in. And I cannot thank you enough for your time and sharing your expertise and the information with us. And I want to remind everybody that this is really only the first webinar about this program, because as we know, there are still details coming out, and those intermediary lenders need to be selected. And so then we really get into it after that. And so we will have future webinars as more information and becomes available. So please stay tuned for those. And Jesse, I'm sure we're going to invite you back again if we can have your time
Happy
again.
to help. Happy to help. No, and this is a great program, and I appreciate what you all are doing. It's because this is especially in the rural areas and some of the poorer areas, and people can be land rich and not have the money to do this. This program offers them the opportunity to clean up a multi-generational mess so that the generations ahead of them don't have to deal with it, because it only gets more complex the older it gets.
Right. I do have a few. So again, we have questions come in, and we'll get to those. But I did want to note, Leah, you that seems like a very short window for intermediary lenders to get to get the applications in by the end of October, or to be selected by the end of October.
It's to have applications in by
Okay.
the end of October.
Okay. And
That's just the first, that's the first window. They will be announcing additional windows in the Federal Register. That's just their first window.
Okay. Yeah, that seemed awfully short. And I was curious then if you already had some, do you have some lenders applying already?
So with the national office handling this, I did not check with them to see if they've had any that have put applications in yet or not. So I'm sorry, I don't have an answer for you for that, but I can for future.
Nope, absolutely not. That's exactly what we're going to be updating folks about. So, okay. Let me go through some of the questions coming in from our attendees. And then again, I probably have a couple more questions as well. But one of the first questions, Jesse, it sounds like this is a question for you. Do inheritance or death taxes become an issue in transfer of farm property? And can the loans be used to pay the taxes due, if any? So maybe that's a two-part Jesse and a Leah question.
I would definitely defer to Leah on the second part. And the first part, and this is the general answer anytime you ask a lawyer a question, and Nicole probably already knows what I'm going to say, is yes, it can be an issue, and it depends on one of the words they taught me in law school, the level of consanguinity. So taxes for a state, I am not a tax lawyer, and I don't do estate administration. Actually, I do the litigation side of it. So take all of this is not meant to anybody as tax advice. It depends on what your relationship to the original owner of the property. As the distance in the relationship gets greater, the possibility of taxes is higher. And there are always costs, irrespective of whether or not there are tax implications, there are always costs of administering a will or an estate, I should say, and including there are fees that have to get paid to the registrar's office just to go through the process. So generally speaking, money is always a factor, especially when you have, as I said earlier, folks that have a substantial amount of real estate, but they don't have a substantial amount of money.
Right, thank you. And I guess, and so just so people understand, so there are tax, I don't know, benefits, incentives that apply to, like you were talking about, the interfamily transfer, right, of wealth through estates versus what would be maybe seen as more of a, I don't know what the term is, but non-familial transfer.
Or familial. So just for example, I believe like a cousin, for example, is going to pay a tax on, if grandmother owned the property and nobody administered her estate, and then it went down to the first level of siblings, and then the next level where you have nieces and nephews and potentially cousins because of one person left property to nieces and nephews, there's a 10% tax that may apply. So that they would individually have to pay. So there could actually be tax on some people that are inheriting the property, not others. And where that could be a problem where you're trying to get it from one level down to the next level. And some people on the second level don't have to pay tax, and some people do.
So more complexity.
Yes.
Leah, do you have an answer about whether the loans can be used to pay any taxes that may be due in resolving the issue?
So they don't specifically mention taxes, but it does include costs for the succession plan, costs associated with buying the fractional interest out, and also to get property and clear title. So examples they give are like appraisals, title searches, surveys, preparing docs, mediation, legal services, but in any title situation, I mean, taxes typically have to be paid current. So I can follow up on that to give a definite answer, but in other programs that we have, taxes are something that can be included to be brought current. Joseph, do you have a definite on that?
No, definitely. But typically with the way our regulations are written, if it doesn't say we can't, then usually we can. So it doesn't fall under those limitations saying that we can't include taxes in it. So I would think that we would be able to, similar to our other programs as well.
And this probably gets too deep in the weeds on the issue, but I would say one thing that everybody should be careful of is, irrespective of who is paying taxes for you, that could be considered income you may have to declare. So it emphasizes the importance of having a team working with you on this. That would include a tax advisor or an accountant.
Yeah, that's good advice. Absolutely.
Point, Jesse.
Jesse, there's another question here. Does air property law vary state by state? And again, I don't know, you're not the expert on that.
Well, the answer again is it depends. Yes, no, I practice in Maryland. I am only licensed in Maryland. So with that caveat, in my experience, the law varies state by state. For the most part, intestate succession. So that's when you don't have a will. When you have a will, the law is, as long as the will is valid, you do what the will said. The taxes may be different at different levels between different states. Inheritance tax at the state level may be different. There are different thresholds that different states use as to what's taxable and what's not taxable. That's going to vary. It's really the intestate, when you don't have a will, that's likely going to vary state by state, because there's a statutory order of priority that determines who inherits what when there is no will. And I will tell you, and then the wild card is always Louisiana and California. They do everything differently because I think they're Napoleonic states, and that's where their law originated from. So they tend to differ. So if you're in the bayou, call somebody in the bayou.
Yes, absolutely.
Yeah, probably does for state by state. If you're in Delaware, call a Delaware lawyer.
Yeah. And just to be clear, it's not necessarily that it's something called heirs property law, but you're talking about estates and where an ownership has been passed either informally, unofficially, intestate, all of those different verbiages that we use. And like you said, each state has a different statute that applies to that situation and through which that property will be administered. So you have to know what that state's,
That's a very good point, Nicole. It really is. I mean, heirs property law is not like real estate law or business law or litigation. It's really a term that we use to generally describe as what you just said, which is the transfer of real estate, which is real estate law, when there's an estate, multi-generations involved, which is estates and trusts law or estate administration law, kind of the melding of the two together, which anytime you meld two different bodies of law, you're going to infinitely more complicated as well. So yes, the law in each state for transferring real property is different, and the law in each state for how estates are administered is different. And then the tax law that applies in each state is likely going to differ.
But at the same time, there are also states that have adopted a uniform model heirs property. Correct. So those states have again, it's under their state statute, how they handle that. So yes, complicated is the word. And Jesse, on that point, I wanted to see if you maybe quickly just could give some folks some advice about who might be thinking, okay, I'm gonna need to find a lawyer. I need to start looking into the resources and how they might go about doing that in Maryland for finding the lawyer who's going to help them put together the plan that they're going to need for the loan.
Call me. I know that was the easiest answer. It depends. Listen, there's no magic to finding, in my opinion. A good lawyer is someone that's going to tell you what they do and what they don't do. I'm hesitant to say try the Google machine, but it will tell you what you're going, and what you want to find is someone that in my experience, someone that practices generally in the county that the property is located in, and somebody that has experience with real estate and estates and trusts. So, and you're often, what you're going to want to find is a firm, a law firm where you have multiple lawyers. For example, my firm, I have a partner that does, and he's a few generations older, a little bit of everything. I have two partners that do nothing but estate administration. I do litigation and some of the real estate transfers, and we work together, each bringing our own expertise. But what I would generally suggest is the law firm in the county in which the property is located. You can, well, to overgeneralize, but most law firms that have been doing it long enough are going to have a website that tells you what they do, where you're going to have a few lawyers or someone that fairly specializes in this. Unfortunately, most counties don't have a centralized resource where you can call a XYZ organization and say, this is what I need. Who should I call? So unfortunately, there's a little bit of, which is why we do these programs, that more people figure out different maybe state agencies that they can call. I get a fair number of referrals from different state agencies from having done these presentations, and this is a perfect example.
Yeah, and I did, yeah, so absolutely. And I did just put up that ALEI's website does have a guide that's put out by the Maryland State Bar Association. It does have a list of attorneys licensed in Maryland. And so you can find them by location. I think they still categorize kind of their specialty areas. So you might look for things like the trust and estates, the real estate, all of that. Yeah.
Those are the two main things. You want to look for estates and trusts and real estate.
Great, thank you. And Roshona, I hope that was your question. I see your hand was up, and hopefully that answered your question. I'm not seeing any other questions right now coming up, and let's give folks just a couple more minutes to kind of digest things and let them bring up. And I don't see any other hands raised right now. And check also that. Okay. Well, I'm not seeing any other questions come in, and we got through a lot of information, and it seems very clear. No more questions coming in, and so I thank you both. I cannot thank you enough. And just, yes, it's such important information, and we're really glad to have your time and your expertise for getting the information out. So thank you again. And keep looking on UMES Extension and ALEI and all of the places that you found the original announcement for the webinar, and look for those future webinars. So thank you so much, everybody. I'll go ahead and stop the recording, and have a good rest of the day.
Thanks, Nicole.
Thanks, Leah. Thanks, Joseph.